To fully understand a charitable trust, it is crucial to digest what charity means. Generally, the word may refer to an organization whose purpose is non-profit in nature, especially an act involving generosity and toward the needy or suffering. Judges have defined charity as a gift for the benefit of the public as per Jones and Williams, where the law indicated charity as a gift to a general public use which extends to the poor as well as the rich. To begin with, for a trust or gift to be charitable and recognized by the law, it must be for public benefit. This means that the gift or trust must benefit the community or a section of the community. In other words, a trust is not charitable if it confers only private benefit. The criteria of public benefit, according to P. Carda, encompasses two aspects in which there must be a benefit and that benefit must be a public benefit. For example, in Gilmore and Coates, it was decided that the goals of a community of cloistered and contemplative nuns were not legally charitable, since benefit to mankind of intercessory prayer and the example of holy life was too nebulous and impossible to prove. However, the fact that a gift is for public benefit does not render it a valid charitable gift if the gift offends other public policy requirements. The rule asserts that where there is a general charitable intention on the part of a testator, the court has an inherent jurisdiction to remove those components of the gift that offend public policy to allow the gift to remain valid, and the intention of the testator will be carried out as via cypress arrangement. Moving on, for a trust to be charitable, it must be wholly and exclusively charitable. With that being said, it must be charitable in nature and it cannot be possible to apply the trust for non-charitable purposes. In Farley and Westminster Limited, where a gift to vicars and church wardens for parochial work was held not to be wholly and exclusively charitable, as it could include work which is not strictly speaking for religious purpose. Also in Chichester Diocesan Fund and Simpson, a trust for charitable or benevolent purposes was held void because the trustee could choose objects which were benevolent but not charitable in law.
This charitable trust is a special kind of purpose because it helps the society, those who are especially in poverty. This can be seen in the case of IRC versus PEMSL, where it helps individual who suffers in poverty. While restrictions can be placed on who benefits from the trust, as long as a significant portion from it, the public receives it, the trust remains valid. Definitely the purpose of this trust is to improve lives of those who are facing poverty by providing resources and of course support. They offer a chance for individuals to overcome their hardships, to improve their living conditions or their lifestyle, and also to regain back their dignity. Charitable trust reflects society's compassion and also commitment to helping those who are in need. This can be seen in few cases such as Engel versus Turner. Next up is trust for advancement of education. Under this purpose, there are different kind of forms of education institutions such as school, university, and also free schools. However, it is important to note that this kind of concept of education extends beyond traditional academic settings and classrooms. As long as there exists a sincere charitable intention and the purpose that serves the benefit of public at large, it can be deemed as valid trust. The notion of advancing education entails promoting knowledge to those who are in need and also learning and skills in diverse ways that contribute to the betterment of individuals and also society. This can include initiatives to provide practical training and any type of education purpose. As long as there is intention is genuine, definitely this trust is valid.
Next, I'll be explaining the purpose of charitable trust in the perspective of an advancement of religion. Advancement of religion is defined as to support the religion to communicate its message to all people and to take active measures to maintain and grow religious belief. It is important to take note that a trust for the purpose of an advancement religion may be regarded as a charitable trust if the trust was made for the benefit of the public. The condition of public benefit would be satisfied in most cases if the objects of a trust involve the public or a segment of the public. For example, we can refer to the case of Attorney General against Lim Oh New and others, where in this case, the public benefit condition was met when a burial plot was given to a clan members, since the clan in question was a part of the community and not a group of private individuals or a mutating group of people. So we can conclude that Advancement of religion can be considered as a charitable trust once it is for the benefits of a public and it is charitable in nature. Next, there are also other purposes of charitable trust other than what has been explained before. These other purposes of charitable trust also required that the object should be made clearly which benefit the public at large and not of individuals in order to make it charitable. For instance, a gift to hospitals can be regarded as a charitable trust if it is made for a public benefit. Other than that, the other purposes also can be found in sports, where a gift made to a specific educational institution with the intention of enhancing the sporting opportunities offered to its students qualifies as a charitable trust as well. Overall, we can conclude that these other purposes can be regarded as a charitable trust once the object of a trust or a bequest is made for the benefit of the public.
In this case, the appellants Nainin Sararaj, known as Nai, and Ho Chun Tat, known as Ho, out to transfer two parcel of lands, namely lot number 10029 to the first respondent and lot number 10030 to the second to fifth respondent in respect of an originating summon known as OS 1128. However, it was argued that both land were part of a public charitable trust for the Burmese community that has been established pursuant to a trust indenture dated 30 May 1845 known as the Trust Indenture of 1845. Hence, because of that title, such land of lot number 10029 and lot number 10030 cannot be transferred in the present case. However, Nine and Ho argued that they have earned the AG's consent dated 31 May 2016 to continue with the proceeding of the transfer of the disputed land in respect of OS 1128. Such consent is obtained due to the reason that the land is no longer subjected to a public charitable trust based on its history of management throughout the years since it has been created in 1845. Then, the respondent filed an application for judicial review to challenge the AG's consent obtained by the appellants. The High Court allowed the judicial review. Thus, in this instant case, there were three present appeals filed by Nai, Ho and the AG against the decision of the High Court to allow the judicial review application filed by the respondent.
Next, I will be presenting on the issues identifiable in this case, which is the first one is whether AG had granted the consent accurately or correctly for the matter that is to be decided by the court. The second issue is whether AG had acted in mala fide or in bad faith in granting the consent to both Nai and Ho in transfer of the land. And the third issue is whether the trust deed executed by the second to fifth respondents as the Burmese trustees for the purposes of administrating trust property and trust funds could override the indenture in 1845. The fourth issue is whether the public charitable trust had been converted into a private trust. And last but not least is whether the separate management and administration for the initial trust signifies that the public religious trust had been converted into a private trust instead. Next, we'll be moving on to the judgment of this case. This court does not believe that the 1994 and 2002 rulings had converted the public trust into a private trust. The AG had left the subject matter on whether Nai and Ho transferred the land to the first respondent to be questioned and examined. The AG had remained neutral in giving the consent to Nai and Ho is to challenge the new trustees' appointment and transfer of the land to the first respondent, and it was consistent to the 2002 consent to split the land into Thai and Burmese portions. The court found that the AG had accurately given consent to Nai and Ho. Moreover, the court noted that the AG had not consented to Nai and Ho in bad faith or mala fide and being unreasonable. His permission is under Section 9(1) of the Government Proceedings Act, which was in his responsibility and professionalism, and it was in the public interest. The court had also said that the public charity trust for the Burmese community, religious goals cannot become a private trust. The indenture was made for a public charity trust for the benefits of Penang's Burmese and Thai communities. It does not give the owner rights to sell, give away, or otherwise get rid of the land, but its goal is to serve and help the communities. So the trustees
could not get and take the power to turn a public charity trust into a private trust by signing a trust deed of a joint venture without a legal consent from the AG. The public charitable trust stays a public charitable trust and does not change what it was originally set up in the indenture 1845.
Basically, in this case, all requirements to create a charitable trust were perfectly fulfilled, as the trust indenture of 1845 is charitable in nature, of public benefit, and wholly and exclusively charitable. Initially, such land is given for a public purpose. Thus, it is held as a public trust for the benefit of the Thai and Burmese communities of Penang since the beginning. The Thai and Burmese community of Penang mentioned here constitute a class of the public, as it refers to a section of the community. A trust created for such a community is considered as a public charitable trust. Furthermore, it is completely clear that this trust is not confined to any sphere of private individuals. Thus, it proves that the trust indenture of 1845 is a charitable trust, since it is made for the benefit of the whole community of some section of it instead of benefiting a small group or private individuals. The action of the court ordering the subject land and trust fund to be subdivided were only to ease the administration and management of the trust between the respective Thai and Burmese community. A religious public charitable trust still exists in perpetuity and does not cease to exist merely due to any change in the way the religious public trust is administered and managed. In addition, such court order obtained by the Penang Burmese trustee in this case is being referred to as for the benefit of the Burmese community in Penang, and another trustee has used the term Burmese community in Penang. Therefore, it is undeniable that the trust in this case is indeed a public charitable trust, because hypothetically, a trust is considered to be a public charitable in nature and in law if it is created for the benefit of a community.
After taking everything into account, for a trust or gift to be recognized as a charitable trust, it must be for public benefit, must comply with public policy considerations, and must be wholly and exclusively charitable. After these requirements are met, only then a charitable trust can function for its purposes mentioned by Lord Macnaghten, where the purposes are trust for the relief of poverty, trust for the advancement of education, trust for the advancement of religion, and trust for other purposes beneficial to the community. The case of NARISYAH and 5-Star Heritage as the NBHD and others, and other appeal has shed light that charitable trust was established as it fulfills the requirements, as in it must be for the public benefit and indeed charitable in nature.